very short meeting, I think, because of the starting this mutual recognition agreement with Australia and New Zealand. It's a letter of undertaking. If you'll refer to page 75 on your pads. That we reviewed at NCARB at the annual meeting in June, voted unanimously to approve this letter of intent at meeting, and I open the floor to any discussion that may be necessary in order for us to take a vote.
Chairman, what they're looking for is signatories to boards to agree to this, and I guess we should ask our legal representation and John do that, or
Australia and New Zealand.
Basically, this agreement states that as long as they're a citizen or lawful permanent residents in their home country, we have validation of licensure and good standing, and they have 6,000 hours, about 3 years of post-licensure experience. They can apply to NCARB for a certificate. NCARB grants them a certificate under those provisions. And with the law change we had this year that allows us to accept applicants, even if they don't meet our exact requirements for education and exam experience, as long as they have the NCARB certificate, we can accept them for licensure at the board's discretion. In light of that, I wouldn't see that it would be problematic to sign this.
Main reason I was asking.
And to add to that, this is very similar in nature to the one we signed with Canada. Is that right, John?
Yeah, correct.
Okay, so there's precedent for
They have to have an NCARB certificate,
correct.
Of course.
Correct.
To
NCARB
be licensed under this provision.
Okay.
Yeah.
And this letter of undertaking will be part of the record without reading it into the record. Right.
That being the case, I would like to move that we go ahead and agree to be a signatory on the agreement. New Zealand and Australia.
Recommend to the full board that we be a signatory, I guess, to the agreement.
That's what I.
We'll have a motion on the table to recommend to the full board. If there are any objections to that recommendation or that
objections,
no objections.
You second it?
Yep,
You seconded. All in favor, aye.
Aye.
Opposed? Okay, the motion carries. For us to introduce the motion to the full board at the meeting when we have our Architects Committee meeting report. Are there any other subjects or any additional items we need to discuss this morning? No?
I move we adjourn.
Second.
Accepted. Thank you. All right. Meeting is adjourned. Thank you, gentlemen. Nice when you only have one subject.
Just on the other side by the electric company.
Yeah, you're on TV.
This is the regularly scheduled meeting of the Board of Architectural and Engineering Examiners is taking place in the room 1B of the Davy Crockett Tower at 500 James Robertson Parkway in Nashville, Tennessee, and notice of this board meeting was posted on the board website on August 1st, 2016. If there are any guests that have not signed in, we ask that you do that at this time. So I want to welcome everyone to our August meeting, and at this time we'll have our roll call.
Susan Ballard.
Here.
Hal Balthrop.
Here.
Robert Campbell.
Here.
Jerry Headley.
Here.
Philip Lim. Susan Maynard, Blair Parker, Rick Thompson,
Here.
Frank Wagster,
Here.
Ricky Versailles,
Here.
Stephen King,
Here.
Laura Reinbold.
Here.
You have a quorum.
We'd like to acknowledge our guests. If you all would please stand up and state your name and your organization. Great, thank you, Larry. Welcome to our meeting. This time we'll have our announcements. I have 2 or 3 brief things. First of all, we want to welcome Blair Parker to our board. He is our new landscape architect representative. And I have been reappointed to the board as a second announcement. And then we're going to announce that Hal is leaving us. He has served 2 terms. Okay, so he will. So we want to thank him for his service. And I guess we'll be moving on to the review agenda and/or changes and/or additions. Is there anything that anyone would like to change on the agenda or add to the agenda? Then we'll move on to the consent agenda. John?
It's on page 90 on your iPads are minutes from the June 2016 committee and board meetings for your approval.
A motion that we approve the minutes as presented? Do I hear a second?
Second.
All in favor say aye.
Aye.
Any opposed? So moved. Next item, is there another?
Staff complaint report, that is a hard copy that's been distributed to everyone, and there are 17 on this one, so it's more than usual. And these are all complaints in which the respondent was disciplined in another jurisdiction. The discipline was less than a suspension or revocation. So in accordance with board policy, we issued a letter of caution and recommend closure. And you can just vote on these as a group.
Your motion that we accept the consent agenda as presented?
So moved.
Do I hear a second?
Second.
All in favor say aye.
Aye.
All opposed? Okay, consent agenda has been approved as presented. Is there another item? Public comment? On to professional society reports.
Casey Anderson with the 2 statewide engineering associations. Couple of things. We have a PE exam review course starting Monday to take them every Monday night through the fall, the October exam. So if you know anybody who would be interested in taking that course, we also, for the second time, are offering that remotely via video conferencing. So we've got a few folks all over the state joining us, which will be nice. We are doing that jointly with the ASCE Nashville Chapter Young Professionals. I think that is the full title of our engineering conference. This year will add the structural engineers to ACEC, TSPE, and ASCE. So we've got 4 groups together this year. It will be September 15th through 18th. At the Music City Center. 2 things of note to this board. One is there will be a decoupling conversation, panel discussion, and sort of town hall type meeting. I'm going to speak. Hal's going to speak, I believe, and a few others. From dissenting points of view, just to make sure that all of those conversations are on the table, because we've been at this conversation for a couple of years now. We will also have a presentation and panel discussion about QBS, and I believe that Robert and John Cothran will be a part of that discussion. So we really appreciate the board's continued help with that event. It's really important to our folks. The only other thing I have is the PE certificates for the new PEs from the spring exam. John just handed me today. Knoxville is doing a special event for the second year in a row it's sort of dubbed the All-Star event. This year, it will be August 31st. In addition to several professional leaders in their community, we will also be honoring the new PEs at that event. We are going to have a similar event for the first time in Nashville to try to replicate that across the state. It was really successful last year. Robert spoke last year and talked about the ethics and the board sort of side of things, and we'll pull a little bit of that in this year as well. So Nashville and Knoxville are having evening meetings to honor those new PEs. The other 3 chapters in Memphis, Chattanooga, 4 chapters, Memphis, Chattanooga, Tullahoma, and Upper East, all have PEs who passed the exam in the spring, and so they will do those honors at a lunch meeting. Any questions?
Thank you.
Morning, I'm Ashley Cates with AIA Tennessee. I have just a few things, not much, thankfully. Our convention is coming up. It's August 24th to the 26th. We've worked with John Cothran, and we pulled that there are approximately 40 new licensees this year since last year, and so we're going to recognize them. The Tennessee Architecture Foundation has offered to pay for their convention registration, and AIA Tennessee this year rented out a hostel for complimentary lodging. So we have about 14 of the 40 attending convention, where we will recognize them at our awards gala with a nice little award. So, additionally, we have NCARB is going to be presenting at our convention this year. So I think pull Rick in there just to have, if there's any questions anyone has. We're excited about that. We also are working, I think at the last meeting we told you all that ACEC and AIA Tennessee were putting on a road show with the Office of the State Architect for the new contract. So that's been done. Feedback has been heard. And we do still continue to have members reach out to us about particular RFQs being released. And so we're working on their behalf for those issues. I believe that is it. So if anyone has any questions or anything.
I've got one quick question, and first of all, I'm glad you said that about the RFQs, because we get those also from Casey, and reminded me how effective, opinion, right, but how effective have people modified these RFQs based on those responses, or just you send out some occasionally for, and I'm sure you do the same for a municipality or someone who is violating QBS or violating what we see as our rules. Are you having success for them modifying their behavior, or are they saying, we think we're right, leave us alone? Well, I mean, kind of how that feedback goes, please.
Yes, is typically very effective. I've got another one that probably will go. Typically very effective. Usually, if it's a municipality, usually it's a quick phone call back to me to just talk about it and say we didn't know, we're sorry. Some of the place we really are having the most trouble is where larger entities that do know better are using master planning. Calling it a master plan to try to skirt around that a little bit, and that one's a little. Those take a little more doing, but I would say that we're at least 90-95% effective with those. The one that our Business Practices Committee is working on is making sure, trying to do a better job of education. This year we're going to reach out to all of the like Tennessee Municipal League and some of those others to see if we can. QBS, but then additionally trying to get the word out to our younger professionals, because what sometimes happens is they get through the process of the RFQ, and by the time it gets to the principal, it's 2 days before it's due, and that's where we run into a little bit of trouble. Every time I've been going around the state a lot and talking to our different groups. Young engineer who says, "Is this it? Is this it?" So there's, I think once they know about it, we'd love to start to get almost like you do with safety discussions in engineering firms. Have those to start to put QBS into some of that, just to keep it on everybody. Other side with the additional services pieces that we're still having some trouble with. Yes, we're having some success getting things fixed, but we shouldn't be having that issue. It shouldn't be happening. So there's a systemic problem that we are trying to address. But that shouldn't really be our job. So.
Right.
I mean, a similar story from the architect side too?
It is, yes. But we normally with the QBS, what happens is members will contact me, and I'll reach out to John to have the state to write a letter, because usually when the state writes a letter, they jump.
And I think they jump better too, because I copy John on everything I do. They don't like that.
Because of the beard?
I will say I've taught some of the larger agencies. I do end up spending some time talking to attorneys.
There's another concern about design build being able to skirt the QBS process. So that's something educated about and be able to see how you can undermine the process. That's the way to go.
That's my concern on that, as well as P3 and some other things too. So I just wanted to, I know we've been fighting that for a while, and wanted to see from your all's perspective how successful we've been fighting some of
Let's ask you one more question. I'm going to open up a can of worms. Have you all finalized the contract with the state architect?
Yes, we have. It was finalized, and that's where Peter went on the road show for the architects and the engineers.
Okay.
And so we didn't get everything that we wanted.
I understand
and
that.
We still have some follow-up clarification that we would like to see happen. There is something within the contract that we want in policy, and so that policy has not been made yet. So we are.
I'll finish that. Does the board get a copy of the contract so we can have it just as?
I can send John the link to it. Sure.
Right. I'd like to see it. Thank you. Who's next, Nathan or Dawn?
Good morning. I'm Don Baltimore, representing the Tennessee Interior Design Coalition, which has now changed its name to Tennessee IDEA, TN IDEA, and IDEA stands for Interior Design. At this time, I want to congratulate Susan on her chairmanship and reappointment, and Mr. Parker for his appointment. Look forward to working with you and the rest. We, of course, he was very appreciative of it, and he won re-election overwhelmingly, and I like to think it was from our efforts. And then as far as the interior design profession and the associations, annual meeting for ASID Tennessee will be September 8 and 9 at the Cool Springs. Is starting to gather funds and award scholarships for NCIDQ registration. And for those of you who aren't familiar with it, that stands for National Council for Interior Design Qualification. Any questions? Thank you.
I'm Nathan Ridley. I represent the Tennessee chapter of the American Society of Landscape Architects. It's nice to be with you here today, even if we're pleased to announce that our conference, our annual meeting, we're not going to schedule at the same time as your October board meeting. 30 in Memphis, Tennessee, and we're excited about that. The program's on a qualification-based selection. I think you have to have the fervor of an apostle preaching the gospel on that, because they just don't know. Sometimes purchasing, procuring your services is not like buying a box of pencils. I can spec a pencil. I want a number 2. You can't buy professional services that way. And when you tell people that, they go, wow, well, that kind of makes a little sense. So just every time you get a chance to talk about it, talk about it. And y'all are the opinion leaders on this. So take it. On the election front, the incumbents did well. Those who suffered self-inflicted injuries are not back with us. Representative Todd from Shelby County and Representative Durham from Williams Assembly that will convene in January. And as Don mentioned, the event that we had jointly among the professional societies for Representative Sargent was appreciated and well attended with good. It is interesting this time as he did 2 years ago. Representative Sargent's in an interesting position. He's always well funded, but his district in Williamson County, people move around. They're pretty mobile, so he has to go to lemonades and ice creams and barbecues and things and make himself friendly, and he did a good job of that this year. President-elect Erin Tharp, and her term will begin from East Tennessee, and her term will begin. We respond to your questions or comments.
Thank you, Nathan. Okay. It's time. I'm going to let our esteemed legal counsel, Ben Glover, take the floor.
Good morning, Madam Chairman, members of the board. We have 6 cases on today's legal report, and then an additional offer from a different respondent to discuss after the conclusion of the legal report. Starts on page 107 on your iPads. First case, 2016-007171, is actually a representation from previous.
There's
That's
one.
what I get for being late.
There are a couple over there.
Thank you.
Okay, so the first case, 2016-007171, is a representation from last meeting's legal report. I will review what was presented then. On or about January 15, 2016, the complainant, a building code official, sent in materials the complainant had been reviewing based upon a submission to the code office from the respondent. The complainant is alleging that the respondent improperly signed and sealed a statement as to structural integrity for a project in Clarksville, Tennessee. Also, the complainant is alleging that the plans do not comport with many code requirements, that the submitted wind speed was lower than the minimum required for Clarksville, Tennessee, the building is not properly classified, the lack of required information for the existing footing/slab, and other issues with the designation and purported use of the structure. Staff opened a complaint based upon these materials for possible practice outside the areas of competence. The submitted materials were sent both to Mr. Richard Bursai and Frank Wagster for review. Mr. Bursai's review uncovered the following. The respondent does not appear to be practicing outside respondent's area of competence, is not holding out to be a structural engineer. Mr. Bursai believes the structure is exempt from requiring a registered professional designer because it is less than 5,000 square feet and it meets other statutory requirements. The case seems to be a disagreement in code interpretation, or in the alternative, the respondent is not taking into account the necessary building regulations. Mr. Wagster's review uncovered the following. The respondent provided a disclaimer statement in the submissions that the respondent is only providing the information that is available from the manufacturer on the specifics of the structural design. Therefore, Mr. Wagster does not believe that the respondent, by stamping the submission letter, either designed the structure or is insinuating that the respondent had designed the structure. That this primarily seems to be a code interpretation issue. The main issue between the respondent and the code official is the building type designation itself, and then the requirements that either stem or abate depending upon the building type designation. The respondent has 2 previous complaints. for practice outside the areas of civil competence, resulting in a formal hearing where a respondent was ordered to pay $5,000 in civil penalties, $6,000 in costs, and pass the law and rules exam. The previous recommendation, based upon the reviews, was to close the complaint. The board in June discussed and decided that we should reach back out to the complaining party or parties and see what additional steps had been taken to rectify the situation. The new report, we sent letters and emails attempting to get in touch with the code official who originated the complaint. Council spoke with the code official and learned that all problems with respondent submissions had been corrected. The code official also sent a letter asking that due to the respondent's willingness and cooperation to correct the issues, the code official asked that no disciplinary action be taken. Based upon this new information, Council's recommendation now is to close the complaint.
Any other questions for Ben? Okay, do I hear a motion that we close the case as recommended?
So moved.
Do I have a second? All in favor say aye.
Aye.
All opposed? Okay, Ben?
Second complaint, 2016017691. On or about March 11th, 2016, the complainant submitted materials alleging that the respondent wrote letters accepting an installation at a project as complying with the proposed design. The complainant alleges that the installation obviously did not comply with the design. The respondent falsely represented the seismic bracing manufacturer's acceptance and compliance with code requirements. Staff opened a complaint based upon these materials for possible practice outside areas of competence and possible selling of respondent stamp. The respondent's attorney responded to the complaint and allegations. The submitted materials and letter from the respondent's attorney were sent to Mr. Bursai for review. His review uncovered the following. The respondent wrote a letter to confirm that an installation is acceptable but never visited the site to see the installation. It appears the respondent wrote and stamped the letter prior to knowing all of the facts, and the statements in the letter were later proven to be incorrect. There's no history of disciplinary action against this respondent. Legal's recommendation is to issue a consent order with a $1,000 civil penalty to take the law and rules exam within 90 days of the execution of the consent order.
Are there any other questions? Do I hear a motion to accept the recommendation by legal counsel? Second?
I'll second, then ask a question.
Okay.
I think good discussion time. This is in line with our penalties. Which ones do we do to come up with $1,000? I mean,
I believe, Larry, is this one that you didn't look at this one? No. I believe there were 2 letters in the file that the individual had stamped, and so I think we were issuing $500 per letter.
Question? Okay. All in favor say aye.
Aye.
All opposed? Okay, motion carries.
Third case in the legal report, 2016035311. On or about May 26, 2016, board staff opened a complaint against the respondent for failure to notify the board of a felony conviction within 60 days of the action. The respondent was found guilty of 2 felonies on January 6, 2016. Felonies are unrelated to the respondent's practice as an engineer. The respondent should have notified the board by March 6, 2016. In a response to the notification of the complaint, the respondent asserted the respondent was unaware of the 60-day time frame for notification. The respondent was not trying to hide the information, and that the respondent had the full support of the respondent's employer engineer firm. There's no previous history of disciplinary action against this respondent. Legal's recommendation is for a consent order with $500 civil penalty and take and pass the law and rules exam within 90 days of the execution of the consent order.
Questions? Okay.
Why is there a civil penalty on this one? Just what's the...
I had our legal intern, Larry Chang, review all previous disciplinary actions with regard to this case and the next 3 cases for consistency, and it seems that this board in the past has issued a $500.
Discussion? Okay, do I hear a motion that we accept the recommendation?
So moved.
Do I hear a second?
second.
Is there any other questions? Okay. All in favor say aye.
Aye.
All opposed? Motion carries. Number 4.
Case number 4, 2016039601. On or about July 15th, 2016, board staff opened a complaint against the respondent for practicing on an expired registration. Respondent self-reported the actions in a supplemental letter along with respondent's renewal form. Respondent has held a registration for over 30 years and states to have missed the renewal notifications, indicating the transition to the internet-based system and also possibly due to the suite number often being left off of the address in the mailing sent to respondent. Respondent was very apologetic and provided the names of the 3 projects respondent stamped while the registration was expired. This respondent has no previous history of disciplinary action by this board. Legal's recommendation is for the issuance of a consent order with a $500 civil penalty and take and pass the law and rules exam within 90 days of the execution of the consent order.
Motion that we accept the recommendation.
So moved.
Is there a second?
Second.
Any other discussion? All in favor say aye.
Aye.
Any opposed? Motion carries. Number 5.
Number 5, 2016-04471. On August 3rd, 2016, board staff opened a complaint against the respondent for practicing on an expired registration. Respondent self-reported the actions in a letter sent along with respondent's renewal form. Respondent has held a registration for over 20 years and states have no excuse for failing to renew on time. Respondent was very apologetic and provided the names of the 8 projects respondent stamped while the registration was expired. Again, there is no history of disciplinary action by this board against this respondent. Legal's recommendation is for a consent order with a $500 civil penalty and to take and pass the law and rules exam within 90 days of the execution of the consent order.
Any other questions?
Just whatever, I reckon linear thinking of an engineer. Somebody that's done 3 projects for 30 years, $500 penalty, 8 projects for 20, and it's the same penalty. I mean, it seems like it should. I don't know if we've got a basis for doing that.
You would want to increase or decrease based upon how long they have held a registration?
No, I mean, it's 8 projects versus 3. I mean, it's primarily what it
Correct.
is, not necessarily the length of time.
Certainly, I mean, legal would be happy to entertain an increase or decrease based upon the number of projects. Again, we had our intern review previous disciplinary action for practice on an unlicensed, practice on an expired registration, and it seemed to be across the board a $500 civil penalty.
And is there a certain amount of time that either one of these cases occurred? Was it a month or 2, or was it
Typically,
a year
it was
or
6 months to a year.
Okay.
Maybe a little
All
bit
right.
more.
Did any of them have comments in regards to our new registration form online, that might have been a hiccup for them or anything like
If
that?
that case number 4, they indicated that perhaps 2 things. One, I did notice that on the letter sent to the respondent that the suite number was left off of even the notification of the complaint. So perhaps those materials for renewal also had the suite number left off. And also, I do think that we have been transitioning to an internet-based renewal system.
Well, a new internet-based system.
Right, yeah.
We've had online renewals for many years, but recently a new system was implemented that does require the creation of an account, so there's an extra step in the renewal process. Makes it more secure, but it is confusing to some registrants, having to set up that account first.
Comments or discussions on this?
I'd like to ask a question. Back to Robert's comment, if my memory serves me correctly, it seems like we issued a fine on each one of the actions at one time, where, and I don't remember the exact number, Counselor, but if there were 3, there were fines. If there were 8, there were 8 fines. I'm just curious if that's correct.
I mean, that's kind of what I remember too, is we've kind of been, because we've even done stuff on a number of pages that they've stamped in a set of plans if we thought they were being egregious. And again, I think this is, understand how things happen, right? I mean, I understand how you get busy, I understand how addresses change, how you think you've sent something in and you don't. I mean, I do it from time to time on things too, but it seems like 8 projects versus 3. I just, I think we ought to bump that up another, at least kind of, it's a little bit more serious, 8 projects versus 3. I mean, to me it is a little bit more serious. So, maybe $100 a project. I mean, something to make it a little bit more serious, or I don't know. So,
I think my reasoning for these 2 cases, in addition to number 6, is that there wasn't really an intent to deceive. it was a mistake on their part, and they were kind of going through the normal course of business. And absent that lack of an intent to deceive, I kind of thought that just this baseline $500 across the board, which coincides with what the board has done in the past.
I find it interesting that they stamped that many drawings and nobody checked to see if they were currently registered for all three cases. That to me says there's another,
Well, that's the responsibility of the architect and the engineer. That's not the board's responsibility.
Well, I mean, the reviewing
Oh, the reviewing,
agency, yeah.
well, do they check
So-
it? Who knows? I mean, I know they check it in the larger cities. But one thing another comment on this, I don't disagree with council on this because in the past when we have had self-reporting, that means a lot. That, God, I made a mistake here. And if he had 8 projects, good for him for having 8 projects. Given the economy, even though it's resurging, and 3 or 8, that's debatable whether that's worse. But I do appreciate the fact that it was self-reported on all these so far, and I don't disagree with Robert in regard to additional fines. But I mean, I'm fine with council's
And I'm okay.
recommendation.
I mean, I'll make a motion to accept council's recommendation at 500. I just, I think the guy that did 3, and again, they may have all happened within a 2-month period, and this guy may have been doing 8 projects in 2 months, the other did 3 in 2 months. So it may, from a time standpoint, may have been absolutely the same. It just, you look at it from somebody looking at it on the outside looking in, and they go 8 to 3. That doesn't. I think I'm fine with 500. I'll make a motion we approve council's recommendation at 500.
Do I have a second?
Second.
All in favor say aye.
Aye.
All opposed, like sign. Okay, motion carries.
Case number 6, 2016026-391. On May 16, 2016, board staff opened a complaint against the respondent for practicing on an expired registration. Respondent self-reported the actions in a letter sent along with respondent's reinstatement application form. Respondent's registration expired in March 2014 and previously held a Tennessee registration for over 15 years. Respondent states to have no excuse for failing to renew on time. Respondent was very apologetic, provided the names of the 3 projects respondent stamped while the registration was expired. There's no previous history of discipline issued by this board against this respondent. Again, the legal's recommendation is for a consent order, the $500 civil penalty to take the law and rules exam within 90 days of the execution of the consent order.
Questions? Do we have a motion to accept the recommendation by legal counsel?
Move to approve.
Do we have a second?
Second.
Is there any further discussion?
I have a comment on this. Back to what we were discussing when Robert brought this up. We didn't have a time frame on these other, and we have this architect that has his license expired in 2014. That's a long time to not know your license expired. That's the responsibility of the architect to keep up with that, not the board, not the review. Wherever the municipality might be, and I don't know how to address this other than in the future. I would appreciate knowing when their license expired, so we could give additional consideration. As Robert said, if they need another civil penalty, then I think it ought to be in our consideration, given the time frame that their license has expired, because I can't imagine letting your license expire for 2 years. I'm sorry.
I do know that the previous 2 cases was a year or less. Mm-hmm.
But then again, going back to that comment, that's just it's extreme for me as an architect.
Would you like to amend your motion, Hal?
Six months following the expiration date, they have to complete the renewal.
It expired in March of 2014, so he would have had 6 months from then. 2 years, if had this individual renewed, they would have been good through March of 2016, which is still 6 months ago.
On your motion?
Well, it's still standing
Okay.
unless someone wants to.
I'm not suggesting we amend it. What I'm saying is going forward, that information would be very helpful in our considerations. We have a recommendation from council and we have a motion on the floor, and I'm not going to amend or try to amend that.
Discussion. Okay, we have a motion to approve the recommendation of our legal counsel. Any other discussion? Okay, all in favor say aye.
Aye.
Any opposed? Like sign. Motion carries. Okay.
Okay, so we've got one more thing to present. Zach Mitschke, the paralegal, is going to hand a proposal to you all. This is a case that was originally presented in February of this year. I can read the original legal report and tell the board what it was that they had issued at that point in time. 2015-022-17771. Again, this is from February 10th of 2016. Allegations of incompetence for plans for church facilities. Reviewer expressed concerns of incompetence concerning the HVAC, plumbing, and electrical plans that were prepared. Respondent also has sheets with unsigned seals. In his response, respondent states that this was a design build with the contractor and the owner. Respondent recounts discussions with the contractor that when changes in the plans came up, he would discuss it with the contractor, and once a decision was reached, the contractor stated he would, quote, take care of it. And respondent did not create revised drawings or follow up. At one point, the respondent states that, this is a quotation, I concluded he, as in the contractor, didn't need me anymore, so I put the work aside, end quote. Respondent also states that he lost several versions of the plans through computer issues. The building at issue has been completed, inspected, and issued a certificate of occupancy. There was a letter of caution issued to this respondent back from 2013. The original recommendation from legal counsel was to discuss two potential violations, unsigned seals and incompetence. The decision that the board made in February was to issue a $9,250 civil penalty in relation to these allegations. I believe it was 6 or 7 counts on one, and then I think 4 or 5 on the other for like the sealed pages. Legal counsel for the respondent, we've been in negotiations with this respondent and his counsel. If I can direct your attention to the handout that Zach just gave you. If you turn to page 3, the legal counsel has proposed these allegations of fact and conclusions of law, where in essence they are only admitting that it is alleged the respondent engaged in 4 professional design activities outside the area of competence, and it is alleged that the respondent also submitted 6 sheets with improperly signed and dated seals. This is not customary of our consent orders that we adopt a finding of fact that there is an allegation. We know that there's an allegation. Typically, with these consent orders, we seek an admittance of fault in lieu of formal proceedings. Also, if I direct your attention to the stipulated conclusions of law, the respondent is admitting the aforementioned allegations of fact if proven by preponderance of the evidence that they could constitute a violation. So again, not admitting of any fault whatsoever. If we look to the order, paragraph 1 of the order at the bottom of page 4, that the respondent shall voluntarily surrender the license with no civil penalty. We are bringing this to you as it is our responsibility as attorneys. We bring offers of settlement to our clients. It is legal's recommendation, and I believe the recommendation of Executive Cothran, not to accept this.
Can I ask a question?
Yes, Laura, please.
To be clear, if this were accepted, then the respondent gives up their license in Tennessee, this would or would not be transmitted to the other states where that person holds a license.
This would not be, as it is not considered formal discipline. In addition, if this individual were to reapply here in the state of Tennessee, there would be no rule or statutory basis to refuse to issue. We do have on the books the ability for the board to refuse to issue a license or renew a license based upon that there has been a violation of law or rule. This particular consent order is not admitting any violation whatsoever. In fact, this individual could just walk in to the office tomorrow and voluntarily surrender their license without any sort of a consent order whatsoever, and this matter would still be pending. We are seeking an admittance of violation of law and rule and voluntary surrender. Our original proposal was a voluntary revocation so that this individual could not ever come back with the admitting of the violation of the law or rule. However, the attorney came back with this offer, and we felt like we should bring it to you.
Okay, so your recommendation is not to accept their offer and to move forward with a hearing?
Well, or to continue negotiations with ultimately the hearing in the future, yes.
To be clear, so if it's revised to include an admission of guilt and
voluntary surrender is not formal discipline. So we could not make someone surrender. We could take someone's license, and that would be considered formal discipline.
but even with the admission of responsibility. I guess the fundamental question is the absence of license
So we have a rule that if someone from another jurisdiction that also holds a license here, if that license in, let's say Kentucky, for example, if they voluntarily surrender their license in that jurisdiction, they would have to notify us. Whether other jurisdictions have that same rule, I don't know.
So that action on our part would depend on the states that individual.
Correct, and I know that.
How would we know that? I mean, unless you investigated, you know.
A voluntary surrender is not the board taking action, if that makes sense. So it would be, we are agreeing to allow you to turn your license over so long as you admit fault, and we will no longer pursue formal hearing, formal discipline. So whether or not another jurisdiction, whether it's California or Kentucky or whatever, whether they have in their statutes and rules a duty upon the applicant or the licensee to report such a voluntary surrender, I wouldn't be able to tell you.
I understand, but if we're seeking an admission.
Yes, sir. I mean, it would constitute, obviously, an infraction. However, voluntary surrender is not considered a formal action by the board.
Okay,
So,
that.
right.
Separate from that, in an admission of responsibility for the infraction, by virtue of that action, to notify other member boards. I think that.
Right.
What you're trying to do. I just want to be clear on the consequence of what we're trying to do as it.
Certainly, I understand. I don't know the answer to that question.
Could we pursue some
We can.
discovery on that and then?
Yes, absolutely.
Okay.
I mean, if I had 5 minutes, I could certainly look that up for you. But right now, if the board wishes to counter offer to this individual, we can entertain that as well.
Robert, would you like to make a comment?
Yeah, I would. I know it's the attorney's obligation to try to broker the best deal for their client, and I appreciate that. This board's made a decision. This board heard facts. This board came to a conclusion of what this violation was. I see no new information in this negotiation or this response or, from the attorney that would change the statement of fact that we came up with during our hearing, not hearing, but our discussion and reviews and stuff. So, I mean, to me, we're negotiating against ourselves with this because there's nothing in here new that would change the statement of fact except he's just saying, hey, it's alleged, but he's never saying, well, this condition changed. And so if we've taken a stance on this and there's no new facts that say anything different, my opinion is we say thank you very much, appreciate you doing your job, but we've come to the decision that we've come to, with a lot of hard work and effort from people on this board. So, I mean, that's my statement.
Mr. Versailles?
I agree with Robert. Sometimes it's hard to remember these cases when they come before the board in February, but I do remember this one. It was pretty egregious, and this, as Robert said, we took action, really, and this is a clear-cut case of protecting the health, safety, welfare of the public. That was the basis of our decision.
Thank you. Yep.
Authorization for a formal hearing, which we would settle in lieu of the formal hearing with a $9,250 civil penalty. And I believe, as always, the law and rules exam.
Voluntary?
No, sir. It was just a $9,250 civil penalty. And in negotiations, happy if this person were to no longer be practicing anymore whatsoever instead of paying a $9,250 civil penalty.
So just to be clear, that
well, the initial offer, as authorized by the board, was for a $9,250 civil penalty, law and rules exam. And then the respondent's attorney reached out to us. I discussed with Executive Director Cothran. We offered them a voluntary revocation with admitting of violation of law and rule. Instead of the $9,250 civil penalty. The return offer was then was not admitting law violation, not admitting any of the facts, and a voluntary surrender, which voluntary revocation would be considered formal action by the board because the board is taking it away without a fight from the respondent versus this person is giving up their, I know it's semantics, but.
So you're recommending
That's correct.
that to go back to what again, just one more time?
Well, not to accept this. I believe Director Cothran and I we would be satisfied with admitting fault, admitting the facts, admitting that there's a violation of law and rules, and the voluntary surrender, kind of coming back to a midpoint in lieu of a formal hearing or the $9,250 civil penalty. This would keep this individual from returning to practice in the state of Tennessee. If this individual were to reapply for licensure here, then we would have on a signed document stating that they violated laws and rules, which would give the board authority to refuse to issue.
So, Robert,
No, I mean, I think, and here's why I think, let me try to think a couple steps ahead. We either have to accept or deny this, right? I mean, we could go back. I think we would wait until we got the offer back that said instead of $9,000, we would voluntarily have our license revoked, right? And that offer's not been made yet, and an admission. And that offer's not been made yet. There's
We
nothing for
made
us
that
to act.
offer previous to receiving this.
Right, but we've not gotten anything official saying they accept that in lieu of a hearing.
No. This is where we stand
This
right
is,
now.
this is what we have. So
That's
this is
correct.
the only thing that we have in front of us to act on. We're just making the assumption that that's another piece that could be put out there in lieu of $9,000.
Yes, sir.
But we've not gotten any of that information from this
No, sir.
and acceptance of guilt.
Correct. So currently, the offer from the respondent is this, and the board can either say no and fall back to the previous offer, which was a voluntary surrender with admitting a fault, or the board, if they wanted to, could counter with some other, $5,000 in a voluntary surrender and admission fault, or we can counter with whatever we want.
Frank, would you like to make a statement?
Yes, I'd like to move that we not accept the counteroffer that's been offered to us.
Second.
Question. All in favor say aye.
Aye.
Any opposed? Motion carries.
I would like to go ahead then and make another motion. I think we've been advised by council and by our board staff that in lieu of the $9,000 penalty, if the applicant would admit fault and voluntarily revocation of license, we would accept that in lieu of the civil penalty. And I think that gives you all, now they know where the board stands. I mean, you've got two options now. We're actually three. Formal hearing, I assume, is the third, correct?
Yes, sir. So just to clarify, I mean, we did offer them an admittance of fault and voluntary revocation.
And they said?
Correct.
Okay, well.
Because the voluntary revocation is considered to be formal discipline.
Okay, well, withdraw any motion I made because there's actually not an offer on the table. I mean, you've made that offer in the back channel, but there's nothing for me.
I would like to make a comment.
I'm good where we are. I'm good where we are.
Give me 1 second.
Okay, sure.
I don't think it's right for us to, vote to impose a penalty and then not stand behind it. I think that's a bad precedent, and that's just my opinion. But if we're going to penalize people and they can come back and say, well, I'll do this and this if you don't charge me, I think that's a bad precedent. I don't think that says that our board, we're going to stand behind what we say and what we mean if we pull it back, unless there's other information like they had mentioned. So, at this point, the board is refusing their offer, and the next step would be for you all to notify them and then wait for their response. Is that correct?
That's right. And
Okay.
with that notification, we can always offer something different. And so I believe that the mentality that Director Cawthon and I had was that, yes, $9,250 is a severe penalty. Taking you giving your license up and never practicing again arguably is
A lot more.
Yes, ma'am. So I believe that's what we were thinking. So not to say that the board's not standing behind its original recommendation, but it's different, but arguably more severe.
Ricky, you recall this case now?
I do, not perfectly, but I do, yes. Yes.
And you felt that, in your findings, that the action we took was appropriate?
Yes, it needed to be a significant penalty because there were a lot of sheets involved. There was really giving up a responsibility that a designer has towards the public and just turning work over to a contractor without following our rules about actually doing a design set of drawings. So, yeah, I mean, we felt like a significant penalty was needed.
Madam Chairman, and my opinion is, let the attorney go back and say it's either, fine or a formal hearing. No ifs, ands, or buts. Trying to wiggle out of it negates what what our responsibilities are as engineers, architects, landscape architects, interior designers for the health, safety, and welfare of the public. That's how I look at it.
Is there any more discussion?
So, since our legal representation and good faith went back to the license
Just to remind you, the original recommendation never included voluntary surrender. The board's decision in February was never included voluntary surrender or revocation. So if we do the fine and voluntary surrender, that's even more than what was originally authorized in February, and which would be.
That acceptable under legal
I
terms?
mean, we can certainly do that. It's just a curious move in terms of negotiating. When we're going even further away from where this, you know.
But I mean, there was an original assessment.
Mm-hmm.
Not going to
Practicing.
resolve.
Yeah.
And maybe he is still practicing, or he or seconded or not seconded.
Okay, so we have a motion on the floor. Is there a second to the motion?
I'll second it.
Is there any other discussion?
Madam Chair.
Yes. Mr. Thompson?
Back to the legal opinion, your first legal opinion was to accept your motion that we were not going to accept.
My recommendation was not to accept. It is not customary whatsoever within this department or division to enter into consent agreements which do not admit the facts of the fault. That's just not something that we do.
That's clear, but I would like an opinion on if we modify the original recommendation, does that open this up to further and further and further negotiation by adding some language to that for revocation or surrender? I mean, are we going backwards on this, or should we stay with the original recommendation that we voted on?
It is my opinion that if we return to this respondent and their attorney with a more severe consent order than was initially issued in February, I think it's pretty obvious that they're going to reject it. We're going to find ourselves in a formal hearing, which is fine. But I just want to prepare the board. That's what's going to happen. Which would, and I know there's concern about this being protracted over a long period of time. This particular case would involve us needing to seek out contracts for expert witnesses and such. And so we're looking at 6 months, a year and a half, or longer before this will ever actually get resolved. And I think it was our idea to try to remove, people don't like getting hit in the wallet, right? So remove the $9,250 civil penalty. Then this individual also doesn't have to worry about paying for legal expenses, hiring their own expert witness. We're talking $20,000 to $60,000 that it's going to cost to represent them if they just admit fault and give us their license. That's what our idea was.
So the motion on the floor from Hal is to maintain the $9,000 penalty plus ask for the voluntary revocation of the license. And what our counsel is telling us is that this may lead into roadblocks in having this person give up their license. And I do agree that again, looking at it for the state of Tennessee and public, the best thing would be for this person to never practice again. That's the goal. That's the big goal. And if the money is standing in the way of that, we need to either, I think, consider counsel's advice to make it more enticing, or maybe lower the $9,000 to something, maybe in half, just as a consideration to alter your motion. To somehow entice the person, because I understand the board's position that we don't want to just totally undo a decision. But I understand at this point that the best thing for the state is if this person doesn't practice.
The original complaint filed with the board? I don't know that it's in this document.
It will not. It should not be.
Okay.
It has a date of 2015, so that could be as. You have it right there. November 19th, 2015.
Laura?
I have one comment and then one question of opinion for council. It strikes me that in a situation like this, if we had intended to impose a fine and revocation, we would have done it, and thought it appropriate, we would have done it at the time. To do so now seems reactive. And in a negotiation, as council has indicated, that's an unusual step. My question to council is, do you feel that if given the ultimate goal is for revocation of the license or voluntary revocation, do you think just simply shutting down the offer and saying, no, we stand where we were, what is your sense of the reaction of how successful that would be in getting the license revoked?
Okay, I'll break that down a little bit. I think if we were to return with the more severe penalty than was ever initially, I think we all know what's going to happen if we offer that. I think if the board just says, no, this is not acceptable, what else do you have, then we'll see what they come up with. And actually, Chief Counsel Glandorf and I have a phone call scheduled with this respondent's attorney tomorrow. I think with negotiations, we kind of, it's like going to the, flea market. They want 40, you offer 5, and you find somewhere in the middle. I don't think that they would then counter with 50 and a ride to the airport. I think going more severe, we know what's going to happen, that they're just going to shut it down. And that's fine. This department is completely prepared to litigate this and seek a formal hearing, no problem whatsoever. Wanting to find a mutually agreeable solution and get this person to give up their license, then it would not be my recommendation to come back with a more severe offer than was initially authorized in February.
My question is, and maybe Rick or might not, is this person licensed in other states?
I don't.
The reason I ask that, he seems real willing to give up his license if nothing happens. That also apparently would enable him to reapply.
Right.
But if he give up his license, he's given up his livelihood, which makes me wonder if he isn't licensed in another state or something, which he can get somebody else to stamp his Tennessee. So that's the reason I'm really against agreeing to this. But at the same time, I don't think I could vote for adding the revocation of the license to a fine that we are with what we've got and go back to them and say, we a counter offer fine, he needs to either accept it. But the other, where I was going with that is, I think that their counter offer of giving up your license and admitting guilt is a lot more, or it would be for me, potentially a lot more of a fine than $9,000. And so I think where we're headed is the way to head, and I would vote against this particular motion.
Okay, Jerry, and then we'll go to Al, and then we'll go to
Okay.
Blair.
One question to council. If we don't adhere to what our original finding of fact and levying fine in that, and we enter into a different outcome, what legal precedence does that set for somebody else that may come before this board in a similar situation. Because if we were to take the same steps we did with this complainant, and then there's a different outcome, that potential new one could say, well, you have set precedent, so here's what, here we are.
Thank you, Jeremy.
I kind of didn't expect the motion to pass, to be honest, but I was interested in the conversation. But financial impact was due to malpractice. Not only responsible for the public health and safety of Tennessee citizens, we're rightfully so, and I support council's decision to counteroffer with the revocation. Kind of on notice now to the public that we felt like that this was serious enough for either license, loss of license is an outcome. I really think we need to be clear on
being new to the process, council, and knowing nothing of this case until today, is there such a thing as a time frame to resolve a consent order? Is this something that has to be resolved in 1 year or 6 months or 5? This could go on forever is where I'm going with this.
Oh, no, sir. It wouldn't go on forever. We have internal policies that handle that. Once a consent order is issued, I can't remember off the top of my head how long, but typically there is a time period with which we can negotiate with individuals until we end up turning it over to a litigator, and then we actually file formal charges and set a formal hearing. And we're nearing the end of that time period. This is
180 days. So.
Well, it's 180 days from the opening of a complaint until the board makes a decision.
Right.
And then we are beyond that because the board made a decision in February, and that was 2.5 months after the complaint was initially opened. Fine in terms of that. But there's behind-the-scenes timelines.
I am not in favor of the motion on the floor at this time.
If I can respond to Mr. Headley's precedent question, that's precisely why we are why it's our recommendation to reject this, is that it is not something that this department wants to enter into where we accept an offer where no one actually admits any wrongdoing whatsoever. Because this person could just quite honestly come inside and just turn and hang up their anybody can surrender their license at any point in time. That's neither here nor there. With them surrendering it because they are surrendering it as a bargaining chip because they violated law and rules and are admitting that in lieu of a formal hearing, that's what we want. We want that nice bundled package. When this person is sitting here saying, no, I didn't, you guys are alleging things and I didn't really do it, but I'm going to give up my license so we don't go to formal hearing, that's not something that we want to set a precedent of. No, sir.
Quick thing, I think we probably could vote. I think everybody's probably heard, but I do want to echo what Hal said, and that's the reason also seconded is if our intent is to keep this person from practicing because we felt that what he had done is so egregious, I think we sometimes look at civil penalties and fines and think, oh, well, poor. But if this person's a bad enough actor, then I agree revocation is certainly worse than a fine, but we probably should have gone down. But anyway, I think we probably ought to. Everybody kind of knows where they're going to land.
Mr. Campbell, and we have.
That's not your fault.
We have in our law and rules, if someone was in violation of a law and rule from Kentucky and they claim to apply here, they have to disclose that to us. If they had a voluntary surrender from California, they have to disclose that to us. Whether those other states have it, it would behoove them to, but I could not tell you sure whether they do or do not.
We had a motion, we had a second. Is there any other discussion? Do we need to restate the motion?
I would, yes, ma'am, I would appreciate that.
Would you please do that?
Sure. So the motion was to
A second to the motion.
Second.
Okay, okay.
I already seconded.
All right. All in favor say aye.
Aye.
Any opposed?
No.
No.
Okay. The motion does not carry. This is a first. Thanks, guys.
Madam Chair?
Yes.
Madam Chair, could I make a motion that we accept council's recommendation? I thought, well, since the motion didn't carry, we don't have to have another motion?
We did that before, and then we added a motion.
Oh, okay, I'm sorry.
So
I
that-
stand corrected.
So at this point, Ben is going to move forward with, you all are not going to accept their offer and see what they say. Okay. All right, then. We have a great discussions. All right. John, are you ready to move on to director's report?
Sure.
Okay.
All right. So I do have a complaint report for you. That's on page 111 on your iPads. So while you're finding that, have an oral report. The architect members and I attended the NCARB annual meeting in Seattle on June 16th to the 18th, and you do have a written report on that meeting that appears later on the agenda. The NCAAS annual meeting is scheduled for August 24th to the 27th in Indianapolis. Got several outreach efforts to report to you. I think Hal and Laura both attended a ASCE chapter meeting on June 16th to discuss a proposal to decouple the experience and exam requirements for engineer registration. And as Casey mentioned, that's another topic that will also be addressed at the Tennessee Engineers Conference next month. I served as a judge at the Technology Student Association National Conference in Nashville on June 29th as part of my outreach efforts. That was exciting. I judged children's stories, which may sound like a nice, cushy assignment, but it actually turned into a grueling assignment. It took like 10 hours to go through all of these entries, but it was fun, but it was a little more of a commitment than I expected. So if anyone asks you to judge a Technology Student Association event, just be aware it may take longer than expected. Also, I participated in an NCARB outreach presentation at an AIA Middle Tennessee chapter meeting in Nashville with Jared Zern of NCARB on July 14th. You may remember Jared. He attended our last meeting in June. Robert Campbell and I, as Casey mentioned, are going to be speaking on QBS at the Engineers Conference in September as well. As far as administrative issues, I'm happy to report that several of our applications are now online. Mostly comedy applications at present. We're in the process of getting our exam applications out there, so we're making progress on that front. Of course, renewals have been out there for some time. We have secured space for our retreat at Paris Landing State Park on October 5th through the 7th. Invitations have been sent to the deans and program directors in the state, and I think I've heard from 12 so far that have confirmed that they're going to attend, so I think we're going to have good attendance for that.
Are they bringing examples of the students' work?
Yes.
Great.
Yeah, I've asked them to. I think you had given me some language to put in the invitation, so they're all aware that that's the expectation.
John, did for the on the architectural side, the presentation by that student association that we saw at the business meeting about what they're doing with as an outreach program, did you put anything in there about that to the architectural schools?
No, I didn't include that in it.
I'll send you an email because I held on to that. I'd like to see what those student chapters are doing. Yeah.
Also, just to let you know that all of our committee meetings as well as board meetings are now being videoed, posted on the website. And I was going to say that the department is testing the live streaming of meetings and that future meetings may be live streamed, but this meeting, it turned out, is being live streamed. So you didn't know that, did you, Susan?
I was warned when I got here.
Okay, you were already warned about it, yes. So this is being live streamed.
No,
so
informed, excuse me.
I do have, well, first of all, let me do the complaint reports. That's on page 111. This is just a snapshot of open complaints, and you'll see that we don't have any complaints over 180 days old without clock stopping action. Our percent on time with complaints in the last 18 months is 98%. So we're Director's report. I do have a legislative update too, if you want me to. I do have a bill for y'all to look at. That is on page, well, a possible bill, I should say. That's on page 63. So you can be turning to page 63. Let me get there. This is in regard to an inquiry I received from the counsel for the Senate Judiciary Committee regarding the reintroduction of a bill to allow persons that hold a master's degree in engineering to qualify for engineer registration. This is the bill that was introduced several years ago, I think in 2007, took effect in 2008, to allow master's degrees. This is just the exact text that was introduced and passed at that time, and they've been contacted by a constituent who has requested that this bill be reintroduced. So I've been contacted about that, and they had asked that it be presented to you to make you aware of this. And behind the bill language, you also have the rule language that was adopted back in 2008 to implement this. Last year, maybe should have kept it on the books in case it was reintroduced potentially, but we didn't do that. So, similar language may need to be adopted if this bill is introduced, if it does pass. Really, for your information, certainly if y'all want to discuss it, I introduced it to the engineers yesterday, and they did have some.
Are there any comments that would like to be made at this time?
Okay. So just be aware that we could be seeing this introduced next year.
Comment when it is introduced or if it's introduced to the legislature?
Take a position on it, yeah, at that time.
We don't need to do it
It'll be
today.
on our legislative
Okay.
report, right,
All right.
when if it's introduced. Also, a legislative request has been submitted to change the requirement for engineer interns, or the requirement for engineer intern certification in order to qualify for PE registration in the law. It's a little bit wordy. It's going to, instead of saying they have to be certified as an engineer intern, it would be amending the law to say that they must pass the FE exam, which is really all engineer intern certification signifies anyway. So it's just clarifying that language, and it's being requested in light of the fact that some states don't certify engineer interns. So it poses a problem when the individuals from those states come to Tennessee and they can't get certifications. Really all we care about is have they passed the FE exam. So it's just updating the statute. The department has been receptive to that proposal, so I think that's very likely to move forward. We also submitted a proposal to change the law to amend our exam application process for architects and landscape architects. That was discussed at our last meeting, you may recall. Currently, applicants in those professions have to come to us for authorization to sit for the exams, and this would have changed the law to clarify that they can just apply directly to NCARB or to CLARB to sit for their test. then apply to the state after they've passed their exams. And that reduces administrative effort on our part, streamlines the process for the applicant, has several benefits. We've since been advised by legal counsel that a law change is not necessary in order to implement that change, but we will need a rule change, which, could be longer than a law change potentially. But we are going to be working on amending the rules. I've already met with our legal counsel on that issue. So that's another rule change that'll be coming down the pike. And I did submit our proposal. We've been submitting it for several years regarding retention of exam credit for architect and landscape architect candidates. Right now the law says they retain credit for any divisions or sections of the exam passed indefinitely. And we've been proposing for several years to amend the law to state that they will retain credit for exams in accordance with the policies of NCARB and CLARB. NCARB has a 5-year rolling clock for exam results. CLARB, they don't accept results prior to 1990 or something. They have some policy on that. So that was submitted, but it doesn't look like that's going to be pursued for next year. And that's all I have for potential legislation.
Grants Committee report. We have met late June to formulate our new special projects grant funding. And we met again yesterday to finalize our wording. And at this time,
Lucky me. Oh, I've got copies.
oh yeah, I'm sorry.
We might need to do that.
Yeah, we might need to do that.
Because they were working on it just yesterday.
Yeah, we fine-tuned a little more wording yesterday, so.
Yeah, it might be good for everybody to know what they're voting on.
Yeah. Like our Affordable Care Act.
Motion or no motion.
Well, I'll take my walk. Yeah. What we have here is the original grants proposal, and then we added our special area for special projects. So what would we be voting on is on the third page that states submission of special projects, what our intentions are, and then suggested topics, our point system for judging, and then that it's going to be an anonymous submittal to a group that will be judging, and then time frame that they have to complete the project and report back to the board with a presentation. The final page shows our point system that we came up with to, okay.
Before I make a motion, does anybody want to spend time reviewing all of this? Or the main thing is, like Susan was saying, on page 3, it starts where the special projects verbiage is added, and everything that's underlined means it's new.
I've got a quick question, if you don't mind. So 20,000 each, so that's 40,000, right?
Yes.
That's for this year. Mm-hmm.
Okay. Where does that fall in? Is everything else good? So that puts our grant at 340, or is it 260 plus 40?
It's under 350, which is what our grant appropriation is.
So
I think we issued 308,000, so we had 42,000 left, so we're going to use the last 40 and leave the other 2,000.
But that's just for this year. So next year, if we go 350, this doesn't apply, or does?
Well, it would. There's a clause in here that states there may or may not be special funds available, and so we are just basing off of this year. So we would have to revise it next year. It's our first shot at this, so we're hoping it will go well. So.
And you might look, one of the items that we did come up with a point system, I guess you'd say, for review of the exams. You might look at that and see if you've, I mean, this is what we've, as you can see, the ones with the heavier points are the parts that we think are the most important, obviously. For health, safety, and welfare. Just anyway, okay, if everybody's had a chance to do it, I would like to move that we accept this revision where the special projects has been added, which includes revisions to the application, adds guidelines, and then has the grant scoring criteria. I would like to move that we accept this.
Other discussion? All in favor say aye.
Aye.
All opposed? Okay, motion carries. Let's take a 10-minute bathroom phone break and re-adjourn at, okay, I'm going to sit back an hour.
It's now 10:30.
Okay, 10:30? All right. All right, 10:30, so 10:45. How's that?
Is it accurate?
Thank you, Frank.
My phone says it's 10:30. I don't know.
I know. See that? I'm all screwed up. Okay, thank you for coming back in. Let's getting started so we can leave in a reasonable amount of time. I believe now we have our engineering committee report. Hal?
Yes. So we met yesterday. I'm going to let Mr. Cochran take some of the content. We did review some and have conversations.
But there was the one motion that was going to add some language about structural engineers to the model law and rules, and we did receive a couple of letters from engineering societies. One was in favor of that, one was opposed. Those who were opposed are concerned, of course, that this may be leading to separate licensure for structural engineers, which was a hotly debated issue at last year's annual meeting, so that's certainly one that will be interesting to watch how that develops at the meeting.
AES has offered to send a
Master's degree, Bill? Yeah, that was on my director's report for the legislative update, but correct that, yeah, I've been contacted regarding the possibility of a bill being reintroduced next year that would allow qualify an individual for registration as a PE. So that was really just for your information.
I guess I'm found out that I didn't listen attentively. Let's see. Group at the conference, is that correct?
Yeah, they're going to have an attendee at the annual meeting, so they wanted to meet with us and discuss it.
Okay. And we did have some discussion about that exam.
Thompson, would you like to do the architectural committee report?
Yes. We met this morning, the Architects Committee, and it's from NCARB, and it's a mutual recognition arrangement with Australia and New Zealand with a letter of undertaking. When this was presented at the annual conference, we were in favor of supporting this agreement, or similar to the one that we voted on and approved in Canada. But I understand that council may have comments on this. Is that right, Ben? I'll defer to council on this. Thank you.
Thank you. Tony Glandorf. I'm the Chief Counsel for Regulatory Boards Division, Chief Counsel for this board. Ben Weavers is the attorney who's assigned to your board. I want to apologize for first, because I just saw this just this morning. So I've had to attempt to kind of consolidate and get my mind wrapped around this agreement. But my understanding is that this would be an agreement between this board and Australia as to the licensing of people from New Zealand and Australia here in Tennessee, and then vice versa, Tennessee down to Australia and New Zealand. It looks like the substance of the agreement, number one, basically states that these boards such as this has the authority to make some type of the authority to determine people's experience and whatnot for licensing. I believe that's true. But when you look at the actual substance of what it's doing, it basically says somebody from Australia and New Zealand who has license in that country, and also NCARB can apply here and would receive license here in Tennessee. Essentially is what it looks like it boiled down to. I'm not sure if you all are aware, but I believe during last session there was a public chapter passed. It was Public Chapter 838, which was a departmental bill, which is a bill that was brought, I believe, to the board, and you all supported that and authorized us wanting to go forward. And the department vigorously requested that this bill be pushed for the last legislative session, and it was approved and passed. And it actually, the substance of the bill actually is of the subject of what this agreement would be, which is it basically allows anybody from any other country who's licensed in that country and has an NCARB certificate to be licensed here in Tennessee, even if they don't meet the other requirements in our laws and rules, so long as the sole discretion of the board feel that they qualify. So you already have that in your statute, and it appears to me, in my opinion, this memorandum and this agreement, signing this, would actually hamstring your ability of your sole discretion for any other reason to deny someone. You actually have more discretion under the statute, and so I'm assuming that this agreement, the substance of it came out previously, and that's why we requested the legislation to be passed. And so I just have concern as to why the board would want to take away their own discretion in this agreement. Is the first issue, because you already have it in statute, and it kind of makes me think it's all for naught that we would have that the legislature would pass this if you all were inclined to be partners of this agreement. So that was the first thing that I wanted to point out to the board. The second thing is that because this agreement would basically be an agreement between the board as to we would approve, like this is an agreement, we are going to approve this. That is determined. That would be an agreement or some document as the determination of somebody's potential property right interest, which under Tennessee law, in order to do that, it has to be either in a statute or rule, and it's not in a rule. It is in your statute already. So I don't really think that this agreement in itself would actually be enforceable and effective in the long term. It would just be kind of a document of we would like to do this, but you wouldn't be able to hold anybody to it. Specifically, you already have it in the statute, and you have more discretion in the statute. You'd be agreeing that you want to do less than that. So that's the second concern that I have. The third is really the authority of the board to enter into this type of agreement in long term. And I just heard that you have one with Canada. I'm not really sure. I really don't want to speak on that or the substance of that anyways, but it appears to me that the body that's allowed to make determinations as to what are going to be the laws and rules as the people obtaining licenses is the legislature. has that authority, and then the board is granted rulemaking authority. And if it's not in a statute or rulemaking authority, these agreements really are not effective. So I don't want to say all of that to say that this is a horrible idea and that NCARB has come up with. I think that what we did is we're probably one of the first states who got on the train, which we actually passed legislation, which is probably what NCARB wants everybody to do instead, is pass legislation that would allow this to happen, is my assumption. And that was done actually last year after a lot of, my office, specifically in our department here, supported that bill and did a lot of, we had a lot of conversations with the legislature and with our representatives up there to allow this bill to. So I would respectfully request that you all not sign this memorandum for the fact that it's already in our statute, and signing it would actually decrease. You would essentially be agreeing to decrease your ability to have discretion to deny certain persons to be licensed here ahead of everybody else, probably. And so, yes, and if y'all have any questions.
I guess one question I would have is the other aspect of that agreement is allowing, in other words, I don't think Australia and New Zealand are agreeing to allow Tennessee architects to practice there. It's kind of a reciprocal type agreement. Yes, we can allow them here without signing that agreement, but I don't know if that goes the other way.
Well, I'm not really sure how the Australian and New Zealand law works as to whether or not their boards, right? It's just obviously I don't as to whether or not they could what their statutes say or what their laws say about how they license people from Tennessee or any other state. I would be surprised that I would be surprised if they didn't look at our laws and rules and say, oh, well, the board can license people from Australia and New Zealand quite easily. Why they wouldn't license people in Tennessee?
Well, I can give you some historical perspective on that. With the Canadian issue, we ran into a case before we became a signatory to that agreement where we had Tennessee architects desiring to practice in Canada, which is not uncommon. I mean, they're just right directly north of us, obviously. Probably would not be as common with this agreement, but could still be a similar issue. Tennessee architects were wanting to practice in Canada, but because even though they met all their requirements for registration, because Tennessee was not a signatory to that agreement, they could not practice in Canada. There was no provision whatsoever in Canada that would enable them to practice without Tennessee being a signatory to that agreement. So I think it's going to, from my understanding, it's going to be a similar situation here. All the Australian territories as well as New Zealand are parties to this arrangement, and if an individual is not registered in a jurisdiction that is a signatory to this agreement, they will not be allowed to practice in Australia and New Zealand. We would have to accept them, I think, based on our laws and rules, if they meet our requirements, but it would not be reciprocal.
Right. Well, if they met all of the new law says if they meet all of our statutory, if they're licensed in their country and they meet our statutes and rules, then yes, we would have to license them. However, if they don't meet our statutes and rules, then there's a discretion of the board not to license them. So you have the discretion not to do that. Also, it looked like, to me, when I was reading the memorandum, it indicated that it appears that it would be effective once half the member states actually signed to it. So they only are asking, there's, I guess, 54 total with the states and territories. So as soon as 7, sorry, that's my math, people sign, then it would be effective anyways. So long on the Australian and New Zealand side, regardless as whether or not Tennessee got on board with it. Now, I know that it may be important to the board to show cooperation in something like this, but what I keep coming back to is that this board actually did something further, more so than just signing a memorandum of understanding, but this board requested us to go to the legislature and push a bill to be passed, which is even more difficult, and that's what's actually been done during this last legislative session that would allow this to happen.
Well, I would clarify that that bill was not necessarily linked to this issue. That's a long-standing issue that the board's been discussing for many years, whether we should look behind the NCARB cover to verify that individuals have met our specific state requirements. versus simply accepting the NCARB certificate. So that's really a long-standing issue that predates this agreement or the Canadian agreement or any other international agreement. Kind of separate issues, but as you say, though, based on the law change, we can, if as Australian or New Zealand architect has an NCARB certificate, they're eligible based on the law. So,
Absolutely. So, if the board is inclined, and I started out by saying I apologize, I just read this morning, so I'm coming down here and doing the best that I can to provide you all with my thoughts and advice on this. If you all would be inclined to, if there's not in the sense of time in this, if you all would like to table this, we can do more research on from our legal office to give you really a good opinion as to your authority to signing these types of memorandums and exactly what it's going to do, and we can bring it back and give you a real proper presentation. I just felt that it was necessary for me to come down here and give you all my thoughts and concerns prior to actually adopting this and trying to in giving you all a broad scope of kind of what I see.
I just have one question. If half of the jurisdictions approve this, it's going to be in effect for NCARB, which will not make us do that, obviously, if we don't sign this agreement. Is there a time frame that's sensitive, John, that we let them know either we're looking at, legal staff is looking at this, or do we need to notify them that we can't sign it just yet, if we can sign it, period, until we get...
I can certainly do that. I don't think that there's necessarily a requirement for that, but they do have a deadline of notifying them by the end of the year, I think, or whether to be a signatory to it.
Oh, okay.
It says implementation of the arrangement is contingent on more than half of all NCARB member boards becoming formal signatories to the arrangement by December 31st, 2016, which to me, that you can interpret that as if they don't get half, then it's dead.
Right. But that gives us the time to defer this
Yes,
for
sir.
2 months. That's my question.
Yes, sir.
Yes, obviously, and if it was it's also a matter that in mid-December this board could have hold emergency non-scheduled meeting to go over this if we needed to. We have plenty of opportunity, I think.
Rick, would you like to make a motion to the board in regards to this?
Well, I would
If we
defer.
make the do we need to make a motion and then table it? If we don't make the motion, we'd just like you to come back and give us a report.
I think you could just make the motion to table this issue. That would be appropriate, and that would be on the.
I move that we table this motion.
It's the motion. What's the motion?
That would be the table this business until next time.
Let's be a little more specific in that motion, because we do have a time frame that we need to try and meet. So, Jerry,
I move that we table the motion about signing the this new NCARB agreement between NCARB and New Zealand and Australia until we have further input from our legal counsel.
Second to the motion? Is there any more discussion?
I have discussion.
Okay.
I would like to see more language in there that that gives us a specific or a more achievable time frame, because that may be next year. It's too broad for me, and that's my opinion, and I will not support that motion as stated.
I'd like
Any other discussion? Okay. Jerry, would you like to restate your motion?
Yes. I make a motion that we table the discussion on the agreement with NCARB and between Australia and New Zealand until we have legal input from our legal counsel at our next board meeting in October, upon which we could then, after their input, either accept or deny the NCARB agreement.
I have a second to the motion.
I made the second, and I agree with the
Okay.
amendment.
Any other discussion? Right in there.
No, just as a point of order, since we are, or understand that if you table something, it takes a 2/3 majority, and I think you have to go 2 referrals in some cases to take it off the table. If you just postpone it, I believe Robert's Rules of Order say if you put something on the table, you have to have a 2/3 to take it off the table, and then you have to have another vote. I'm not trying to get technical, but if somebody does that, that would be.
As a point of clarification, was there ever a motion on the table? No, not Jerry's motion, an original motion about voting on this. There's no need to table it if there was no original motion. No motion is needed.
Thank you, Rob. So where do we stand? We need something pretty quickly. It'd be
Tony
nice.
has asked that we make a motion to give direction to legal counsel as to when to report back. Is that correct? Okay.
That would actually be very helpful for
Okay.
us because it'll be in the minutes. So that
Yeah. Okay. Would someone like to make a motion to give direction to legal counsel?
I move that we give direction to our legal counsel regarding the NCARB New Zealand Australia agreement and bring forth their findings at our October meeting.
Second. Second. Any more discussion? All in favor say aye.
Aye.
Any opposed? Motion carries.
Amen.
Thank you, Tony. More committee reports from the Architecture Committee.
Madam Chair.
All righty.
Thank you.
Okay, John.
112, you have action items carried over from previous meeting. Items under my name are, the first one is in process. I haven't been able to get in contact with, or haven't heard from officers of the Middle Tennessee chapter of the Association of Energy Engineers. So as I indicated to the Engineer Committee yesterday, I'm going to contact their national headquarters regarding the Engineer Committee's request. Legislative proposals have been submitted, as I reported earlier, and the Grants Committee, of course, has done their work. The topics for the October meeting are being included on that agenda. And then there were a couple of items for legal counsel also.
First item is still pending. First and second item are still pending. We'll hopefully have more for you guys.
On the action items, the Grants Committee has completed their task. Topics for October planning session: discussion of alternative procurement and delivery methods, including public-private partnerships. And Engineering Committee has 3 items there as well. Is there an update on those, gentlemen?
I did contact Ashley Cates about a speaker. You had asked that someone come and make a presentation on alternative procurement and delivery methods. Say that she had contacted AIA National on that issue, and they are willing to provide a speaker for that event. They were asking, though, they wanted to confirm the subject matter, if we wanted them to cover all project delivery methods, and I think the answer is yes. That would include design, bid, build, CM agency, CM at risk, design build, and P3. So I think all of those would be included probably in that discussion. And they also asked if you wanted someone who was located in Tennessee or if they could potentially be from another state.
I think I was the one that made some of that request, but I would prefer, I think we're all fairly familiar with design, build, but the others definitely would be nice to hear. And if they were in Tennessee, that would be a bonus. But if there was somebody more qualified that they felt from somewhere else, I don't know that we're particular. I'm not particular about that.
That complete everything? Okay, all right. Rules update.
We are planning on, I believe we discussed this yesterday, and perhaps this morning, drafting some rules for your review with regard to the examination application process for the architects and landscape architects. those should mirror one another so that we've got uniform language throughout the rules. In addition, I believe we also draft some for them just for their review, and hopefully have those ready for you to see in October.
One item of unfinished business. A year ago, we had a hearing for Mr. Comp-Perry. I was following that payment. He has not made his payment. As of August 23rd, if he hasn't made his payment, then his license will be revoked. So they're monitoring that. The legal office has sent him letters. So we're on the countdown with Mr. Comp-Perry. So just with that. Okay, moving on to new business. QBS?
My name's not there, but I'll start it out.
His name should be on there.
Yeah, this has already been addressed somewhat in the
Yeah.
professional society reports, but some concerns about QBS and basic services. And Mr. Wagster had sent me an email on this issue after attending a presentation by the state architect, and there was some concern about it opening up the possibility of reverse fee bidding. Do you want to go into that, Frank?
I wasn't really prepared for that, but, and Casey, you're more familiar with this than I am, actually, so if you would.
So the issue with basic services and additional services, which was the purpose of our legislation last year, one of the come up that was addressed in 3 of the 4 meetings that we had around the state with the state architect. 2 different times he said it one way, one time he said it an alternative way. We have some concerns that ACEC has some concerns that we all agree that there should be no fees connected. And the way we've negotiated the contract for additional services and basic services, there is now wording in the RFQ process in one of the 3 procurement methods, but one that they use the most frequently. There is wording in the RFQ that says everything you submit, everyone on your team who you submit up front shall be considered basic services. Shall fall under basic services, with the assumption that we are not requesting any additional services. If we do at some point, then we will negotiate those later. So the issue that has come up is, say it's surveying that you know that they're going to need, and you include surveying in your initial submittal. That's now a basic service, and now the state can look at that and go, well, over here we're not getting that from. If we know we're going to need it, this guy's going to ask us for additional services. This guy's included on his basic services team. So it's sort of, or a historic, say you have a historic preservationist that you're including on your team up front as a basic service, and you're willing to eat that cost. You're basically going in and saying, I'm going to be cheaper on the front end, on the qualifications end. So that question has come up in several of these meetings. I had maybe 3 different meetings. The state architect made reference. The only time he didn't exactly reference it was when Frank was actually in the room. But 3 different times there was some reference to, well, I've already discussed this with the board, with the A&E board, and that you all would be, they could then, the state could then just take those if they're egregious, and someone's clearly saying, I'm giving you the whole, everything under the moon, that they could then take that and send it to the A&E board for you to monitor or penalize. And I think it was in the Chattanooga meeting when I very off the cuff, perhaps inappropriately said, will you do that before or after you choose them? Because obviously that, from the state perspective, I think there's some desire that's a desirable feature because they are looking at cost all the time. So the issue has come up, and it has been, in some ways, thrown back to your court to discuss. We are actively continuing in this conversation about advising architects and engineers on how to ask that question appropriately in pre-bid meet or thank you. Not a bid meeting, but pre-proposal meetings where it was asked one way in a very direct method that was considered antitrust, which I thought was maybe I didn't really see it that way, but there's some specific language that the state needs to hear about that. You can't just say, what additional services are you planning to have in this? You know, what down the road are you going to get? But it's an issue that we have some concerns about, and a little bit on both sides. There's a great example of the historic preservationists where, you know, an architect said, I knew that was going to make. I thought I would be able to make a better building that way, and I knew it wasn't something they were ever going to pay for. And it wasn't going to cost me a lot of money, and I thought it was something I could afford to do, and I thought it was important to the project and the work I wanted to do. And in that situation, yeah, we get that, you know. But then there's the other side where you're really looking at, you know, somebody who's got everybody on their team, and it does become a bid situation. And so we've got concerns about it that we don't quite know how to address because, according to the state architect, that is your jurisdiction. Does that make any sense?
Correct me if I'm wrong. When did he come to us and talk to us about any of this, as he stated in that meeting? Did that happen? Okay, I'm just curious about that.
The only thing the reason I sent John an email is at the Memphis meeting that I was at, he said directly he'd talked to John Cothran and he was okay with this. Heimbach hadn't been before our board to.
Madam Chairman.
That was a good explanation of a complicated issue there, and I think, and I guess right now the board's role is to just kind of discuss this and see if there is a role that we play. And I think that the whole notion behind QBS is that if we didn't have QBS and we just selected designers on cost, and it's proven that the cheapest design costs the state money. That's been proven over and over again. And I think that it's comparable to say that people giving away free additional services could end up costing the state money. Getting a free acoustical consultant or a free other survey, what are you really going to get versus when you pay for that service? In the end result will cost the state less money. That's the whole idea behind QBS, and I don't see any inconsistencies with the services that happen to be termed additional. So I think it's a problem that can be solved because I do think as you stated it is a form of bidding, and I don't know why the responses couldn't be. Why couldn't be instructed to say you're responding to basic services or to these selected additional services that the state names in its request for proposal, so that everything is apples to apples. Then when you get into negotiation, if somebody wants to give away additional services, I mean, that's part of if you're selected and then you're in negotiations, then that's part of that. But it seems like it's a doable, that we could come up with a doable procedure and still not bid services.
I would agree with that. The issue that we are up against is the state publicly is of the opinion that they and almost never require additional services. So there's no reason to ever, they will not, going forward, they will not likely have additional services included in an RFQ unless they go, there's three procurement methods. One is the basic services. One is negotiated additional services that I foresee being used almost never, where that's told to the respondents up front. And the third is a complexity multiplier, like they're using for the State Museum. My understanding is that their intention is to use this very sturdy line about all of this shall be included in basic services going forward, so that there has to be a discussion of additional services when those come up and when they're requested, to make sure so that it doesn't get out of hand and they can plan accordingly. I would love for that method to work, but they're of the opinion that they're unnecessary. So in most cases.
But the good thing is there's a defined list of additional services. I mean, there's a list.
Correct.
So if they say we don't need additional services, but by the way, you better provide landscaping.
If somebody comes in and says, I'm going to give you my asbestos guy up front in your first package, then it's not an additional service. You're not getting paid out.
And that's where I say I would be in favor of the board saying that's bidding services.
Okay.
That just stick to the basic services or named additional services.
John, can you invite the state architect to come to our October meeting and explain their QBS process so the board has an understanding, and maybe we can get a better idea of this, since there seems to be gray area, or you go one or this way. So if we could request him to speak on this at our October meeting, I think it'd be very beneficial for us.
I would say probably October or December, possibly, since October is at Paris Landing, which is a little drive. I mean, his schedule may not allow that, but certainly December, I would think, at least would be a possibility.
Robert?
Yeah, this is first blush, so without too much thought put into it, but I would agree with Ricky that if the 10 items are listed, that's what you should put in your proposal, and that's what you should be evaluated on. Anything else would be now. But at the same time, I don't want to take away a firm's ability to make money by including something for free. And I'm going to give you a quick example. That would be in our case. We've got survey services inside our house, right? And it actually, even though depending on the scope and size of the survey, by the time I took somebody else's survey, got it into the form that I could use it in, put everything in it, the different codes, and work back and forth, it may be much cheaper for me just to go ahead and do it. And I would just throw that in and say, I'm going to save X number of dollars here by not having to deal with somebody else. I think that's, to me, but that's an after-the-fact discussion. It's not, I'm going to include it up front for you. And so I think I agree with exactly what you're saying. At first blush, that makes sense. And the same thing with an archaeologist. I mean, you all may have one in-house that you're paying salary to anyway, so they're going to use 10 hours, and to try to go out and contract with somebody may cost you 20 hours, So I think that's probably up to the firm to decide if they want to throw that in after the fact, not on the front end. So again, that's my first blush opinion.
The question that has come up as well is who's in charge. and so some of that is those decisions on.
Based on the meeting in Chattanooga, what I took out of that meeting was that if you go by the new contract, the new agreement, there are things that you can or you should, as basic services, provide, and then there again the additional services. And I agree with the fact that if you go in and you include an additional service in your basic services, that you're in violation of this QBS. Now, the other thing I would suggest to everybody that if you haven't looked at the new agreement before the state architect or anybody else talks to you, read it. It's very informing. If you haven't read it, read it, because you may or may not agree with what all the basic services are. I certainly don't. And I know a lot of architects and engineers who don't agree with that, but it's what we got to work with. And if I have to include something as a basic service and the fee does not support that, then I so choose not to submit my qualifications on that job. That's going to be your call. So that's up to you. If it calls for acoustical engineering, that's a basic service, it's your call.
It should not ever call, that's the other piece that we're monitoring. Engineering should not, if that is required in the RFQ.
Right, but that's the monitoring part that someone has to be aware of, and I think that does fall back on the professionals to some degree, because we are aware of what we can and cannot do. So ignorance of the law is not acceptable here, because you know what you're supposed to do.
And the trouble is they'll give you an RFQ for a state-of-the-art music facility.
Yeah.
Under the basic services model, knowing, and sometimes they will, there was a dining hall recently, and the dining services, Earmark or whoever it was going to provide that kitchen consultant. But our response was, everybody who's even looking at this assumes that they are going to require a kitchen consultant. Where is that in this RFQ? And
yeah.
So that's, and it's,
and that was,
you name the
and
one
that was
you
a
would
good
like to work
example.
With, that's part of your qualifications is we have a relationship with the best kitchen consultant in the country. Well, that can't be considered as part of that piece, because it will then, as soon as you say that, it's included in your basic services, and everybody else is out of the game. So
I think where I think we can go is if the board considers this, like Robert said, this is kind of a, I guess, our first discussion on this. But if we think that including these additional services in a request for proposal is not meeting the RFQ or the QBS law, we can encourage the state architect to, if they get a proposal with those included, throw it out. And that won't last very long. Once people hear that you're thrown out if you include additional services, it won't happen very long. And the other thing is, if a complaint about it comes before the board, then we deal with it. I mean, that's our mechanisms.
I had a question. You want me to ask the state architect to come to a board meeting?
Are we going to challenge what he said? Stating that we had, backed what he was doing without any consultation?
Appropriate probably would be is if we have questions of the state architect, or we feel like there are issues that he is asking us to respond to, or maybe has brought to, that would be appropriate for him to get into conversation. I certainly think that it might be helpful. This has come up a lot.
If we do invite the state architect out of courtesy to him, I would think that prior to his presentation, we should have a list of appropriate questions, because I will caution you that when he was in on the road tour, or whatever they called it. When he was in Chattanooga, he spoke for 2 hours. So if you want him to come and present, I think we all need to be prepared to either listen to the 2-hour presentation or get the abbreviated version, which I don't know that that's going to be helpful to us to get the abbreviated version. So I'm just, out of courtesy to the architect, state architect, and he's got lots of things to do, if we do invite him to come, I think it's incumbent on us to let him present the full presentation. So just letting you know.
Any other comments?
I guess one comment that may have been what Ricky said, but my impression on the meeting that I went to is that they plan to take full advantage of additional services as part of their basic services in a way for them to save money. Directly said this is what we're doing, but that it's that would give, that's the reverse fee bidding part of it. I mean, the state by formula tells you what your fee is. So that's a level, but what you propose may have a whole lot of additional services. And, kitchens come to, if you're doing a kitchen, that comes to mind. You need a kitchen. I submit a proposal that's just the basic services of MPE and structural that you normally have, and as listed as that as basic services in the contract. Expect them to pay additional money if they want to pick out where my competition, if you want to call it that, can throw in a kitchen consultant and their basic services, and so the fee that I would get paid for basic services compared to theirs now is two different things. But they don't want to, it's like Casey was saying, yeah, they gave us all kinds of new additional services, but they don't intend to pay for any of them. That was the impression I got.
Meetings were vastly different from place to place.
So they changed their tune by the time they got.
Please, you answer the question.
I was, so I missed the Knoxville meeting, which was the first. There was one in Upper East that we let him kind of go alone and see what happened. But the Knoxville meeting was
contentious.
Contentious, thank you. I was trying to think of a nice word, and that would do. The Memphis meeting they were just dramatically different, and the tune about the conversations and the responsibility, I would call it, the responsibility that he was placing on you all for this grew as we moved around the state. And I think by the time Rick was in Chattanooga, by the time we were there, it was in your court. He was less open about it was already a done deal with the state board because he knew you were there. I am of the opinion, and I'll try to speak for the boards of ACEC and AIA. I think I've spent enough time with their executive committee to say that I think that they would appreciate a conversation between the board and the Office of the State Architect, just because they are attempting to push responsibility to you that you're not in a position to take unless there are complaints. And so that's, and I don't think you need to go through the 2 hours of the whole thing. I think it's this specific topic that relates to you all that I think is important just to clarify.
Don, do you have any other comments? Okay.
I believe they're first.
I'm sorry. Who went first? Robert? Okay.
So,
Sorry.
it's all right. So yes, I think we ought to have him here in December. I believe this is something that we need to do sooner rather than later. But I would like and I just want your opinion, do we have 20 minutes, 30 minutes at the retreat, maybe after we talk about the different delivery systems, because it's kind of on the same page, to get a set of questions or a set of things that we want to talk about, and maybe broader topics, I don't know, but I agree with you. I don't want to hear every component of the process, but I would like to hear the parts that interact with us and that interface with us. And this seems to be the key issue that we're talking about, is when is it QBS and when is it not. So again, I'm in agreement for December, but I think we ought to try to carve out some time in our October meeting to get a set of questions, and that leaves 2 months to have a formal answer, but it's already on his calendar as far as being here, if that's acceptable.
Ricky?
I think that's a great idea, and it's appropriate if we can get him to a meeting in December. But I think this issue, we've been talking about this issue for 4 or 5 years. This singular issue of additional services versus basic services and QBS, we can restrict the discussion to that, and apparently it's being thrown to the board, or maybe that's a bad term, but pointed to the board to say, what is your position on this? I think when we talk about it at the October meeting, I wouldn't mind if we make a stab, or I'll suggest that we make a stab at writing our position on this issue and just see what, sometimes in that process, what comes out of it. Can we not write a concise position that the board has on this issue about whether this is or isn't bidding? And then that's something that we can, at that point, present in the right way.
Yeah, the main issue that affects the board is the procurement method. And I think your idea is good. I think writing taking a statement, taking a position is good. And I also think you'd be really good at writing the initial attempt at doing that and bringing it, and then we'll wear it out. If you're willing.
Yeah, absolutely.
Well, I hate to interrupt.
Suggestion?
I think
go ahead, Tony.
I think your legal counsel should be a part of that.
Yeah.
Because you're just basically saying that you're about to interpret the law and provide that, and I don't think anyone's qualified to do that except for at least me and Ben here. I'm not sure if anyone on the board is an attorney, but I think the boards at times do take positions on things or whatnot, but I think this statutory scheme is very different than many other boards in that this actually is not under your statutory scheme that you administer and authorize under Title 10, Chapter 4. But we'd like to work, with you all to kind of go through the language and whatnot if we could. I think that'd be a great opportunity for us, because we can write and draft opinions for you all on that, and then usually the process is if there's any question or whereabouts is what that is. The Attorney General's office does a good job of also drafting opinions that every state agency and board would have to follow. And we went through a process last year, I think, when Ellery first came on board, where we went up there and the Attorney General's office had pulled every Attorney General's opinion regarding this, and there was not much. There really was not, and there was just a few lawsuits that had ensued in it, because I'm sure if you research the lawsuits, it's really a question as to who's going to actually prosecute something like that, other than one firm over the county or municipality. And I think that probably doesn't happen so often. I could kind of understand why with that business relationship, but I think we'd like to be a part of that if we could.
And that's fine. We know the mechanics of how it works with the state architect and what the contract says. And however, if you wanted to take a first stab and have us review it, or have us draft something and you review, either way, whatever you think is better.
Well, yeah, I think the question I'm pausing because usually when we do attorney's work, we usually start with a firm question. a very exact question. I think that's what we talked about. That's what you all were stating, that you would come up with a series of questions. So maybe if we come up with a series of questions first, then we can go from there as to who would take the first stab. Because, like you said, you all have all the expertise, knowledge as to actually how all of this works within the field, and I think all of that is absolutely relevant. Because the statutory scheme is very just.
I'll probably write my question with, "This is what I think you ought to say. Is this okay?" That would be my question.
That's what a good client would do, right?
Yeah, right.
John, I think the consensus of the board is that we're going to invite the state architect in December. In October, we'll work on our questions to him. If we get him on our calendar for December, on his calendar as well, tell him he's going to have 30 minutes, 40 minutes, 45?
Whatever he needs.
Yeah, put it at the end, after lunch. So anyway, and then in October, let's plan time as a group to come up with our questions and concerns, and then be able to turn them over to Ben. Is that enough time for you all, gentlemen? They're not listening.
I apologize.
No, it's okay. We are going to come up with our questions and comments in October.
Yes.
And then turn those over to you. Would that give you time before a December meeting to review them?
No, I hate to promise that because I will try my best to, but it would probably have to go through several levels of review in our legal office. So that,
I'm thinking in terms of a list of questions to present to the state architect, not saying that we're going to come up with the policy statement yet.
Oh, yes, okay.
Is that appropriate, Ricky? Is that what you had in mind?
Yeah, I was kind of serious, even though I was joking. But I
took you serious.
Again, I think what I would like to do is just state why we think this is bidding, what we think is bidding about this situation, and why we think.
Do we want to come up with a statement before we talk to the state architect, or after we have?
What I was suggesting is if we go through the process of trying to come up with a statement, maybe then questions will arise. If we look at a statement and say, wait a minute, that may produce questions that we can discuss with him, or it may be pretty clear, because like I said, this isn't a brand new issue.
It is not a brand new issue, and I think it's important as we go forward, if we're going to regulate what this is, that we need a defensive position. And I think our legal counsel is going to provide that. And if we have the questions, and if they can advise us on the questions, but not necessarily get a formal opinion, I don't think we're going to do that by December. But if we have a direction in which we're traveling, and everybody agrees that that's a good direction, I think that's what I'm looking for. So.
One thing I would like to ask John or somebody to do, and Rick brought it up, is if you hadn't read the new agreement, it'd probably be a good idea to do that. And Casey, you may be able to get it to us, but anyway, I think everybody on the board needs agreement, and then the procurement method, which was, if I remember right, was a page with the 3 different versions of that on there.
I can get the state architect's handouts from those meetings.
We have a consensus that we want the state architect scheduled later than December in order for us to have time.
Oh, I mean, I think December is fine, and I don't think we have to have a position ready in December. In fact, it's a more convivial relationship, which may or may not be to have that discussion before finalizing a position.
Are we finished discussing this topic at the time? Any other comments? Okay. All right. Let's move on to committee assignments. So that is on page 113 of your iPads. And at this time, since Bill Lockwood is no longer with us, Blair on the following committees, which include grants, laws
You're
and
on them all.
rules, publications, licensure, nominations, and continuing education. Once Hal's replacement has been named, then we will go forward with reassigning those committees. Your motion that we accept that?
You may
We do.
want to assign a new chair for the engineer committee, since
Okay.
it's almost certain Hal
Thank
will
you.
not be. And also for licensure outreach, I don't know if Mr. Parker will want to serve as chair. But that committee will meet in October, so it's pretty quick.
Are there any volunteers for the engineering chair, or do I need to? Well, Philip is secretary, so we don't need to
Not here.
overload him at the moment. Laura, would you chair it this year? Licensure outreach. Stephen, would you do that one, since I don't want in there? It's not fun. So anyway, okay. Did I take care of everything, John? On to the October agenda meeting. Do we need to do a motion for that? All right. Okay. All right. So page 114, October meeting agenda. Did you want to go over?
Yes, I can go
anything?
over that. So Wednesday, October 5th, beginning at 1, of course, this is at Paris Landing State Park Conference Center. Wednesday is when we have the profession-specific committees meet. So we'll have the Interior Design Committee, followed by Landscape Architect Committee, then the Architect Committee, and then the Engineer Committee gets most of the afternoon, since they tend to have the most business and applications to review and such. And I do have on their agenda a discussion of discussing the FE exam waiver that's in the law, where if registered applicants have 12 or more years experience, the FE exam is waived. So that was one item that y'all wanted to discuss, as well as continuing education uniformity and outreach to employers regarding the experience requirements. And then for Thursday morning is when we have our meeting with the educators. Of course, as I mentioned earlier, they've all received their invitations. That's when they'll do presentations on the grants. And I'm sure at this meeting also we'll be discussing the special grants projects with them that were the guidelines that were approved at this meeting. And they'll provide updates on their programs. And we'll have breakout sessions for the architecture, landscape architecture, and interior design educators, as well as for the engineering educators. With the engineering educators, definitely want to go over the new engineer intern application process. We changed that last year, where the engineer interns no longer have to apply to the board to sit for the FE exam. They just go directly to NCEES. They've all been informed of that, but I don't know how educated they are on that new process. Also, at that point, we'll have online applications for interns, and that's going to change the manner in which we verify senior status for applicants. Currently, the dean signs the application. Well, when it goes online, it's no longer going to have a signature on it, so we'll have to verify through a different method that a student is in good standing with senior status at his school, his or her school. Then in the afternoon, we have the Law and Rules Policies Committee meeting. Do have one proposed bylaws change to discuss. That's combining two of our committees into one, publications and licensure outreach, combining those into one outreach committee, which I think would be a good. We have the grants committee, continuing education, publications, licensure outreach, the finance committee, and then in the afternoon, I just put down, I thought that would be a good time to discuss the different procurement methods. We could have a speaker come and address the board on that issue. Well, they're still separate committees until the bylaws are changed, but I guess they could meet at the same time,
I
potentially.
was going to say for efficiency, if we're intending to, or if the intent is to do that.
Well, I mean, they meet
find a new
they
chair
meet
for
back
the
to back,
licensure.
so yeah, they're sort of already kind of combined in a way. One can just spill over into the other, I suppose. Yeah, actually. Oh, he is chairing both.
Well, then it works.
It does work. Yeah, I guess we could do that. We could just combine them into one meeting. Yeah, that would make sense. Here we go. All right, we'll do that. And that'll give us maybe just 30 minutes for both, and then that'll give us a little more time for the discussion in the afternoon. All right, good suggestion. And then Friday, of course, is our regular board meeting. That's when we'll have the committee reports and any action taken at that point. That's the agenda. And also Friday, we will have an open forum for registrants, building officials, anyone who wants to come address the board. You know, we had quite a few when we met in Chattanooga last year. Wouldn't anticipate very many at Paris Landing, but you never know. There are registrants that live in that area, so they'll have an opportunity to come. That's it.
Would you like to head up the 4:30 meeting on our discussion of alternative procurement and delivery methods? Sure. Okay. Other questions or comments about our October meeting? Okay. All right. The 2017 meeting agenda, it's on page 120.
Always challenging trying to fit our meetings into the schedule. February, got proposed dates of the 15th through the 17th, which should provide adequate time for any bills to be introduced, so the board can review those when we do our legislative update. We do have an NCAAS Board President's Assembly on the calendar earlier that month, the first week. And the NCARB Regional Meeting, March 9th through the 11th in Jersey City. Now, April, I think at least one person, I think, I'm sorry, it wasn't you, it was Laura, yeah, had a conflict potentially on those dates. We selected April 5th through the 7th. The next week, Good Friday falls on that week, and Easter's on the 16th. And usually we have that Friday set aside for formal hearings in case any are scheduled. We reserve that day for formals. So we could potentially move it to the 12th and 13th. We just wouldn't have that formal hearing date available in April. And it's right before our state holiday on Good Friday. So but when is your conference?
That one, the spring was April 5th through 8th.
We could move it to the 12th and 13th. We just wouldn't have that Friday available, whatever the preference of the board is.
We're moving the meeting for one board member?
I'm just asking. I'm just asking because
we don't have to.
You don't
It's
have
just
to.
a possibility.
You don't have to.
But we do lose a potential formal hearing date. I don't know what the likelihood is of having a hearing, but we could.
You don't have to.
No, if we're having a Good Friday holiday, I mean,
Or do you take that?
I do.
And later that month, we have the NCAAS Southern Zone meeting in the Virgin Islands.
Realistically, none of us are going, right?
I don't know, honestly.
Well, I was chair of the site selection committee.
I think it's dicey whether we'll be allowed to go to that meeting or not, since it's a resort location.
If they paint their own way, then
$1 per diem?
perhaps they want to go on vacation.
It wouldn't help much with travel expenses. Anyway, yeah. I'll meet with our assistant commissioner about that particular meeting and see what the likelihood is of us receiving approval. And I would anticipate we would not try to send very many delegates to that meeting, maybe just 1 or 2 delegates probably. I think that would be more, they'd be more receptive to that than us sending like 6 engineers to that meeting. Now for June, we always have problems in June because of the beloved CMA Music Festival. That's June 8th through the 11th next year. During that week, hotel rooms are just very difficult to obtain. So, the following week, I'll say, is the NCARB annual meeting in Boston. And then, usually we don't want to push it out too far into the month. So really, it looks like the first week of June would be the best time for that meeting, which actually pulls us back into May for one day, May 31st through June the 2nd. So usually we don't have a meeting at the end of May.
Don't have the National Rifle Association coming into town at the same time again, do we?
I haven't checked that. I wouldn't think so. They move that around, don't they? It should be in a different city next year.
That was also a problem last year, so.
About that one. We always track the music festival, though, because we've had problems with that in the past. So that's the tentative dates for the June meeting. So the actual board meeting will be June 1st, but some committee meetings will be on the 31st of May. August 9th through the 11th. NCAAS annual meeting be the 23rd through the 26th of August. Then we have the CLARB annual meeting the 13th through the 16th. And October 4th through the 6th would be our tentative dates for our planning session. And that will be, normally what we've been doing is even years we have it at a state park. Odd years we do it on a campus, a university campus. So about possible locations for that meeting, we don't have to make a determination now, of course, but we'll need to pick a university to meet at for that meeting.
John, didn't Vandy Engineering offer to have the meeting? I think they brought it up last year at the state meeting.
At there in 2007 or 2008, I believe. Yeah.
They want to show, because they want to showcase their new building.
There are several institutions we've never met at, but there's smaller schools that may only have one program. UT Martin, little isolated, smaller schools like Christian Brothers, Union.
How about UTSI? UT Space Institute.
No, we've never met
down where I am.
Yeah, no.
John Vanderbilt would make sense because I think we've been to.
Might be a good possibility. Okay. Possibly Vanderbilt. Yeah. And then November 10th to 11th is the CIDQ annual meeting, and we would propose the 6th to the 8th of December for our last meeting of the year. There's the proposed meeting dates for next year.
Motion to approve this?
The meeting dates, right. Yeah.
Do I hear a motion to approve?
So moved.
Is there a second?
Second.
Any discussion? All in favor say aye.
Aye.
Any opposed? All right, motion carries. All right. Our 2016 NCARB annual meeting report. Who's going to give us that?
For that? I wrote the report, so I'll do it. It's on page 121 on your iPads.
Golly, I'm sorry.
Rick? We did meet in Seattle, Washington. A good time was had by all. Had quite a few resolutions presented for votes at this meeting, more than usual. One was in regard to the arrangement with Australia and New Zealand that's already been discussed by the Architect Committee and Legal Counsel earlier. That motion did pass 45-8. So I would anticipate, they'll probably receive majority of signatories to that, likely. Resolution 2016-02 was revising the guidelines for architects that don't meet the standard path to licensure, formerly referred to as broadly experienced architects, what the requirements would be for them to obtain certification. That resolution passed. Resolution 5 addressed changing the model law and rules to allow access to the ARE for students enrolled in an integrated path to architectural licensure option. That's the option where they basically are licensed upon graduation. Their education includes their internship, taking the ARE, and all that. That's included within their program. So they'll be eligible for licensure upon graduation. So some states have those programs that are, it's a kind of a pilot program at this point, but several states do have schools that are doing that. And so they had to adopt some model language for adoption in those states.
I believe the first two schools were SCAD and Clemson were the first two that, yeah.
I don't remember the exact number. At least 14 schools, I think, that have these programs currently.
SCAD is Savannah College of Arts and Design.
And also they did change the name of the intern development program to the Architectural Experience Program. They're moving away from using the term intern. There was another resolution that was discussed at the regional meeting that would have removed references to the titles intern architect and architectural intern from the model law and rules, but that one was withdrawn because there was so much concern about that expressed by member boards. And that's all I have, unless the architects want to add any comments.
John? Looks like our final item is the authorization of travel and speakers.
Well, you've already authorized Robert and I to speak at the last meeting at the engineers conference. And I believe, were there a couple speaking about decoupling?
Signed off on a NICE visit.
Right. But Laura would be participating, right? You're not sure? Okay. Well, scratch that. We're not sure. Okay. Okay. But Robert and I are authorized, so
okay.
We're good.
All right.
Yeah, if you want, I guess you might as well authorize it.
Are there any other items that need to be presented to the board? Okay. Well, I thought you didn't know yet, so I'm apologizing.
Okay, yeah. Go ahead and authorize me so I don't have to come back. Just in case.
Need a motion to authorize travel for Laura to...
So moved.
Do I hear a second?
Second.
Any discussion? All in favor say aye.
Aye.
Okay, last item of business. Hal would like to make a brief statement to the board.
Brief being the key component. I do want to thank the staff. Y'all been very helpful and patient, and funds that we have available and a good representative on behalf of the industries represented. Council, I haven't dealt with you guys much, fortunately, which is a good thing, but we're always benefiting from the legal counsel that we have, and we've had a few during my tenure, and they've always been very responsive and helpful. Board members, I thank you for your support and your the education I got from you, each of you. I've learned a lot from you. I've benefited personally. My replacement, the three candidates that I'm familiar with that are being considered are very good. Thank you all, and good luck to you. And I meant one more thing. The association members, too, our representatives, have been very helpful and instructive, and
Okay, at this time, we would like to have a motion to adjourn our meeting until we meet in Paris Landing State Park.
So moved.
Do I hear a second?
Let's go.
All in favor, say aye.
All right.
Thank you all.
Somebody's going to have to do the cocktail bar at the annual meeting. I won't be there, so.
BYOB.
That's going to be tough.
One cocktail.
You don't partake, but.
Here's my building.
Yep.
So this
we're
is
gonna fill
covering.
that in.
Okay.
Oh, yeah, have a safe journey back.